What up, YouTube? It's been a long time since I did a YouTube video, but today is April 27, 2011, and it was very necessary that I do a YouTube update. As you all know, my sister is a political prisoner, and her son was kidnapped by the state of Wisconsin and given to a rapist. And she was charged with interfering in custody of her own child. Today, I was in a courtroom. Now, I'm not going to name the so-called parties, not right now, but I'm going to keep you all updated. Show you that Milwaukee County Courthouse is a criminal enterprise and they are profiting off of our children. There is a man who has custody, joint custody of his child with a woman he's not married to. Okay? And he's being charged with interfering in custody beyond visitation. Repeater. Now, he doesn't have visitation. He has joint custody of his child. I'm doing a YouTube today because we're going to do a compare and contrast, and it's going to show you what is really going on. It said he's being charged with taking his child away for more than 12 hours beyond the court-approved period of physical placement of visitation from a legal custodian with intent to deprive the custodian of his custody rights without the consent of the custodian, contrary to Wisconsin Statute 948.31, subsection B, 939.50, subsection 3. Let's just go to 94831B. It is an affirmative defense to prosecution for violation of this section if the action taken by a parent is taken by a parent or a person authorized by a parent to protect his or her child in a situation in which the parent or authorized person reasonably believes that there is a threat of physical harm or sexual assault to the child. If the parent is also fleeing a situation in which the parent reasonably believes there is a threat of physical harm or sexual assault to himself or herself, it's otherwise authorized by law. So there are defenses. If you're authorized by law, or if you're the parent, you take your child and protect your child. This woman, she has a very sordid history. She was a former prostitute. There will be evidence presented that, this woman goes to like liquor stores and pick up other women. There's drugs and alcohol done in her home in front of this child. And she has a boyfriend that has beaten her in front of the child, and has also threatened the child. So the father of the child, now the woman supposedly is saying that, well, he just took the baby. Now, this man has a copy of the key to her house that she gave him, but her boyfriend has her concocting the story. Now, this man that's the father, let me tell you, he just did 3 years in prison and was exonerated for police misconduct. He has a permanent plate in his hand for being abused by Milwaukee police. He has a dislocated jaw, permanent dislocated jaw. He's been abused by Milwaukee police so many times, and he's always fought back. Okay, and when he was arrested at the woman's house, bringing his son back to the house. They had no warrant. His son wasn't hurt or what have you. So, this woman, who's been convicted of, I think, forgery, criminal dwelling, a number of different things. Now the man has been charged, plenty of charges in the past, by Milwaukee police and allegations and what have you, and he's always fought. The man is exonerated, cleared of the charges he spent 3 years in prison for. This is his only child, his only son, okay? And so when he got out, there is this story concocted. So now he's facing over 20 years. They're charging him with interference with custody beyond visitation, criminal trespassing, dwelling, domestic abuse, battery. Today he asked the lady in the courtroom, did you have medical attention? If you were battered? No. Did the police call, ambulance? No, nothing. They didn't even call the police to the stand. And guess what they didn't do? They didn't bring the custody order. Because there's an order that says he has custody of his child. Joint custody. But there's a Milwaukee circuit judge, a woman. Now, wrong is wrong. Her name is Ellen Bromstrom. She told him today, when he asked for a speedy trial, he doesn't have a right to a speedy trial because he's not in custody. United States Supreme Court already ruled speedy trial rights attached when you're arrested. You don't have to demand a speedy trial because it's your constitutional right, but he verbally asked for one. And not only this case, I took note of other cases where this woman was slamming men, in particular black men, where it was women. It was a woman. Her name was April as well, but the guy who was being charged last name was Sanders. This woman admitted that wait a minute, my child wasn't hurt and what have you, and the little girl allegedly stole something from school, and the man had no record. And you should see the misconduct they did in that case. You know, and where the judge was telling women, now I saw this myself, women who wasn't even abused, to go to a Sojourner Truth house for abuse. I mean, automatically you tell she was biased against men. And I think in particular the black men that was in there. You know, she just copped an attitude when black men were in front of her. And everything the state said, she did and abided by. And she was advising women. There was a woman named, I don't have the paper in front of me, but I took note. There's another woman who wasn't abused. She advised that woman to go to a Sojourner Truth home. Now these women were before her as defendants. Okay? They were defendants, the women. Okay? And then there also was a woman, I don't have my notes in front of me, but as far as my recollection, this woman, she told her to go to a battered shelter or what have you, and she was the one who did the battery. You know, but this man is being charged. And then the district attorney, assistant district attorney, Matthew, yes, his name is Matthew, this is real deep, troublesome or what have you, made a false statement that he knew to be false about me. Because yes, I was there watching the whole thing, and I personally know what's really going on. And so he says a false statement that the woman supposedly said that something happened in the courtroom. But you have everybody in the courtroom watching. I was in the front pew. You know, and after the woman got done testifying, she walked past me and made a threat to me. And the people in the front pew saw that. But the assistant district attorney says a paralegal came up to her in the courtroom. Come on now. Said she's a paralegal. He knew he was lying. So I asked him his name in the hallway. I said, you made a false statement under oath. He said, I didn't make the statement under oath. Statement he knew to be false. And he's only doing that. This is being done for political reasons. This is being done because this is a criminal enterprise. And, you know, there's video. You just don't know. Exculpatory. That means in favor of the defendant. Now here it is. April Griffin. Police kicked in her door, took her son, broke her baby bones, paralyzed her, and gave him to a rapist. There is no custody order where she agreed to any of this. There is no legal orders. Now you got this man who's being charged, who has custody, joint custody of his son. And let me say something. He asked these questions and the judge did not want to answer, nor did the DA. He asked the woman, do you have a criminal record? They didn't want her to answer that, and she didn't have to answer. He said, do you and your boyfriend consume alcohol and marijuana in your home? This is one of the points in where when a child is in danger, they're doing this in front of the child. She didn't have to answer that question. He said, as an infant, was I not an active participant in our son's life and help you raise the infant until I was in prison for a charge in which I have now been exonerated for approximately 3 years ago? She didn't have to answer the question. Haven't you concealed my son from me